So I was wondering if you could possibly clarify, help me. I don't have my glasses, so it's kind of hard. So on, I don't know, you've got those fake ones? That's
No,
good.
these are real ones. I'm blind as a bat. Those are real.
Oh, no. Yeah. So on,
We might have some more assistance here.
oh, thanks. Pardon? I'm sorry. Oh, the cheaters, okay, good. Oh, yeah, these work. I guess this is just all I would say is just to consider this after I kind of lay this out a little bit. Where it says 9151, second page, lines like between, section 2, where it talks about, which may include an individual as well as a business, that section. I'll lay that out a little bit later, but I'm just asking you to look at that for a second, so I have just for reference. And then, could you, and on the record so that I understand it a little bit better, clarify lines 24 to 27? Could you?
Trying to bring it up now.
Oh,
But if you have
sorry
a
about
question,
that.
you can ask it.
I apologize. No, I'm just basically asking you to clarify that section. Carol, that was the part that I was,
So we're on page 2.
yeah, sections 4, lines 24 to 27.
24 to 27.
Yeah.
Well, basically what that addresses is, when we were here last year, the language that was proposed by the church was that all claims under the new legislation would have to be prospective, meaning that only those persons abused after the date of passage of the bill would be able to benefit from the extended statute of limitations. What this does is says, if you're 10 years old right now and you're being abused, you get the full effect. If we pass this tomorrow, this is your statute of limitations. Even though when you were born, it was only 7 years statute of limitation, it is now going to be changed. And since your statute has not ticked out yet, you get the benefit of the full 35 years once you hit 18. That's
Okay.
what that addresses.
Okay, so that's what I thought.
Yeah.
But I think that it's kind of been confusing because it leads people to believe, in general, that it might be a look back or.
No, that is
an
not the
open-
look back. The look back is line 15 to 23. This is just including,
Right, and that's, so if you could look at it from just another perspective,
well, we
does this negate that period, that area? Do you know what
no,
I'm saying?
because this
Okay.
is saying that if the action is not otherwise time barred, where when you go to line 15 through 23, those actions have been previously time barred, and now this window is a one-time only window where they can come forward during that period, it's 3 years, and bring their lawsuit. And now, whether or not they can prove it is a whole nother story, and we know that. But in many of these old cases, they do suffer from evidences lost, memories fade, witnesses die. A lot of that is true, and as you know, Mary, and they become very difficult to prove. So the window is line 15 to 23, and the other the line 24 to 27 just verifies that if your statute has not ticked out, then you get the full benefit of the legislation, which would be the 35 years.
Against an institution.
Against institution and the perpetrator, both. That's why there's two different paragraphs at the top.
You look like you were going to say something.
Go ahead.
I do. I want to add something. I just want to make sure she was done. When Mr. Silverman was here, do you recall me asking him questions about whether his only objection was really lines 15 through 23.
Right.
You didn't have a problem with 24 through 27. 24 through 27 is an important protection because it means that if you've already been abused, say you were 14 and you got abused, and you're now 17, and your statute of limitations hasn't run yet, you still get the 35 years.
From the time you become your age of minority?
Exactly.
In other words, you've already been abused, that's already done with, but you still get an improved statute of limitations. Your statute of limitations hasn't run yet. but-
Understood.
Okay,
So-
so
so it
that's
was-
what those two provisions do.
So I'm not sure, like, I'm just from my perspective, the latter part of the language sounds like it negates. It actually negates the window. So if, maybe some language could be put in there so the intent is shown, because I can tell you some of what I've been through.
I just want to say
I-
one more.
Go ahead. Go ahead.
On the legalese, it does not negate it.
No, I mean, if you look at 15 through 23.
Yeah, no, that's clear.
And line 2, who have been barred from filing suit against their abuser by virtue of the expiration of the statute of limitation.
Understood.
Under the previous version of the general laws. Then you go to 24 to 27, and it says, if the action is not otherwise time barred it's totally different language. Under a previous version of the general laws, on the effective date of this section may be commenced within the time period enumerated in subsection A1 and A2 of this section. So
Right. I understand
think
the
it's very
intent.
clear.
I do understand the intent. I'm not sure that
Well-
can get, I'm just sharing that with
Okay.
you. Because I have, so for example, and then I'll lay it out a little bit better. I'm so happy, thank you all. I don't know what time it is. I know I have a court date tomorrow, so I'm tired, but one of my last experiences, 23, 22, 24 years ago, this same issue came forward to this very committee. And we were greeted, it was very different back then, but we were greeted with, and in my ignorance, I didn't know, I remember one of the first times that it was Robert Flaherty that was the judiciary chair, and he got up knowing that there would be no quorum, and back then they'd vote that night for committee, and he left because there would be no quorum. And we were there till 3 o'clock in the morning, victims, and talking about sexual abuse and statute of limitations issues regarding the institution. The Constitution already provides criminally, it already provides an avenue when there's a trial by jury. And if you're wondering why I'm so tender about words, it's because I, in fact, went through a criminal trial with the Roman Catholic Church, or, Monsignor Dunn. He was convicted after a non-jury trial because he waived his right to a jury trial because he was so confident that he would, be exonerated. And in fact, he was convicted. And an automatic judgment should have gone in. There's a statute 1228.5, which says, after a trial by jury, or it did back then, a person will be, you'll get an automatic civil liability will be attached. So it's a no-brainer. Why would then my case get dismissed on the statute of limitations, and why didn't that ever happen? And some of the conclusions were, well, gee, it wasn't a trial by jury because there was just a judge. Well, a judge is a jury, right? It's a jurist. But that's how the system worked, or didn't work for me. There was a history of the same statute of limitations issues. Rhode Island has, for the perpetrator, the person who physically sexually assaults you, has probably one of the better statutes already available to the perpetrator that physically, does their thing. But it doesn't extend into the institution, which is what I think you're trying to correct and extend, and I think it's great. What I would ask you to consider, in part, is that the Catholic Church, in fact, is a little bit different than the rest of the institutions. So this would probably be great for, Corporation X or Corporation Y, or maybe even DCYF, because I saw that you put the state in there. But for the Catholic Church and the Diocese of Providence, or the Roman Catholic Bishop of Providence or Corporation Seoul, it's a little bit different, because they have a thing called First Amendment stuff, and I can give you a couple of, if you will, concrete examples of how they've circumvented the law of our country and our state. So there was a case with Father DeRosier, and some of you may remember it, some of you might not have remembered it. The victim had repressed memory at the time, and they had to be subject in the criminal trial to what you call a quattrochi hearing. So they had to kind of make sure that her memories were valid, for example. So it was a pretrial measure. And at the time, the bishop was Gelano, and there was a Father Godin, and he acted as the church's psychiatrist. We have a statute called 91723, which is like the priest penitent statute, so it's a privilege. And so basically what happened is, from what I recall, Bishop Gelano gave the state police and the Rhode Island Attorney General's office a statement acknowledging that this Father DeRosier gave him a statement that, yes, indeed, this Father DeRosier admitted to both him and Father Godin that he had committed these crimes against this young victim. At the pretrial stage, which, by the way, affected also her statute of limitations in the civil case, right? At the pretrial stage, they went before the court, and it was Judge Needham, and Bishop Gelano and Norman Godin were called to the stand, and both of them said, I cannot acknowledge or deny, because Rhode Island General Laws 91723 deems me incapacitated to testify in anything. So now the judge was like, oh God, what do I do? So he asked Father Godin, he says, well, did you intend for this conversation to be confidential between, you and, the bishop, and you and Father Godin? And of course he said yes. And so as a result of that, they couldn't, they weren't able to use the evidence of those statements. And on the same time, on the flip side, I observed the same diocese that knew the truth take a psychiatrist named Tom Paolino, who I think he's since passed, and tear that victim apart and say that she was making false claims, she didn't know what she was talking about. And so that's a piece of what we go through. So the victimization that you go through with the person is awful. It really is. But when you come forward, which is a real challenge, whether you remember it or you don't remember it, it takes a lot to go through. And then when you do go forward, anybody who lies, I have to tell you, they deserve everything they get if they're lying, because it's a cruel system. Not only do you go through the stuff that you go through, but the court system itself, the legal system, is another layer of trauma, we'll say. But my point is I'm really glad that you are expanding this. That guy that was here mentioned the constitutionality. is that the man you were referring to earlier? He was questioning the constitutionality of the statute that you're talking about as in retroactive. Was that?
Are you talking about Silverman?
I think
the
so. I
attorney?
wasn't sure if that was the same person.
He was talking about the window. His problem was with the window.
Right.
So, and only that.
Right. And I think that there's some case law, because I followed it. In 1996, there's a case called Kelly versus Marcantonio.
I'm going to ask you, I'm going to interrupt you because there has been case law that upholds the window throughout the different states. So,
Yeah, I think it's great.
it has not been tested here, but we have neighboring states where it has survived. So,
Well, yeah.
I
and
feel
to-
it's
yeah.
got a lot of legs.
Yeah, no, to your point, there's, the magistrate Hagopian in 1988 in the St. George's case actually used the discovery rule, which was what you were referring to with the medical malpractice and the product liability, right? You were referring to. He applied that in that case. There's a case out there, I think it's in 1989 he came down with it. Then when the Kelly versus Marcantonio case came out, Judge Letterberg dissented, and she went through a long discussion about that. And something that I'll share with you that was interesting about that is there's tolling statutes that we had, which was 9119, 9120. And in 9119, there used to be a little piece of it that you could utilize, and there was 4 reasons why the statutes could be tolled. One is that you were imprisoned, you were out of the country, you were of unsound mind, or you were, you were the age of minority. And the age of minority, that was the other thing I was concerned about in this particular thing. You need me?
Go ahead.
The age of minority. In one of the cases, in the sexual abuse cases, which was very sad, it was dismissed, and I think, Carol, you can look it up, I want to say it's either Roe versus Gelano, I'm pretty sure it's Roe versus Gelano, and there was this quirky thing, and I don't know the years it handled, but the age of majority was 21 at sometimes in that period as well, so it fluctuated. And so I remember the victim was within the time, the statute of limitations, but they went to the Supreme Court, and because the church raised the issue, even though that wasn't what they were talking about, the church raised the issue that the person was actually within the statute of limitations, it was dismissed anyway, and said you didn't raise it, so you're going to waive it. So it's very sad. So I guess when I see here, I see the age 18, that maybe as a protective measure, you could look at that 3-year span and make sure that people who at one point had that 3 extra years don't get, just don't get affected negatively by this. Do you know what I'm saying?
No. I mean, the age of majority is 18, period, and that is the law. So, I mean, with any statute of limitations, whether it be 3 years, 7 years, 10 years, 35 years, the clock doesn't start ticking until you reach age of majority, unless your parents bring a suit on your behalf when you're underage.
Right. You're misunderstanding me. What I'm saying is that there's been times during that period of time that
So you're saying back when the age of majority was 21, which was, when was that? Back in the 70s,
I'm not sure.
maybe?
It might have gone to the 80s. I'm not sure, and that's why I'm saying it. That's my only point.
Well, the only thing I can say to you on that is the age of majority is right now, and I think the judges would have to determine whether they're going to add the 35 years to 21 or to 18. I think this bill is pretty clear that it's 18. I think you're saying if somebody was abused before the 70s when it was 21, I think that's what you're trying to say,
What
right?
I'm saying to you is rather than utilizing maybe the age 18, stating the age of majority. And that way, whatever time period that is,
Well, you know what, Mary, I mean, we'll consider it, okay?
And it's really all I'm asking you
Yeah,
to do.
we're listening to you, so, I mean, I don't know what I do know what the answer is, and I've been a lawyer for 33 years, and I think this language is good. But if you want to differ, you differ.
I'm not differing with you. I'm just asking you to look at some of
I've
these
looked at
things
this
because
inside and out, so.
I've watched over the course of years. I've been, I went through a criminal trial.
I know you did,
I
but,
went-
okay, I've heard you. I mean, I don't think we have to
okay.
keep going over what the age of majority is. I understand what you're trying to say.
I went through the civil system.
Mm-hmm.
There was a conviction, and somehow my case was dismissed.
Mm-hmm.
Okay? And all I'm saying is there's another layer, and even though we don't want to separate the Catholic Church from everybody else, there's a reality because they have been able to utilize statutes and other situations to circumvent our law. And another part of it which is tied in is, for example, the reporting law, right? There's the child reporting law. The Attorney General's office last year made an agreement with them that, they're going to report. And then if you look in the memorandum of understanding or the letter of understanding, and you go down, I think it's section 4, it says something to the effect that we agree that, communications happening under Rhode Island General Laws 9/1723. In other words, those communications are protected. And the statute itself.
I think you're talking about something that's not being addressed here. And
I'm
I
trying
wish you
to
would just
address-
stay on the topic.
I'm
because
trying to address
the bill
it,
is as
Carol.
clear as we possibly could be. We've gone over this. I've gone over it with several different lawyers. We've had several lawyers here tonight say what a great bill it is. Lawyers who practice.
I'm not criticizing you, Carol.
Well, I'm just saying, you keep arguing about this, but
I'm not arguing. I'm sharing information that has allowed the Roman Catholic Bishop of Providence, a corporation of soul, to use our laws to circumvent the statutes. And to this point, when you were talking about intentional conduct, if you know, for example, you're talking about the institution, right? And showing that they have intentional conduct. That's where you're going with this, and I understand that.
the word is, it's not intentional, and I will stand corrected on
Okay.
saying that. I'm saying that, I was trying to point out the difference between medical malpractice, product liability, and what we're talking about here.
Yep, okay.
That the conduct on behalf of the perpetrator is intentional. And I was just trying to,
I understand.
we're not talking legalese here, it was just talking
I understand.
about making the comparative difference. So let's just get to what it is you're concerned with the bill, and you don't like the 18, you're concerned about the window, and you're concerned about
I'm concerned about,
paragraph
I'm not concerned
24
about,
to
Yes.
27, those lines. Okay.
and I'm not concerned about the intention of this bill. What I'm asking is, and stating is, if you let me finish and not interrupt, because it's...
Well, I will interrupt you, I mean, if I feel the need to do so, but go ahead.
And
I think that Representative McEntee's general point is just to stay on the topic of this bill. We're not addressing other potential legislation, and you may have other valid points, but if you could limit your testimony to the bill before us, we would appreciate it.
And that is what I'm doing, sir.
Thank you.
And what I'm trying to articulate is that, for example, I will give you another example to show you my concerns about how this can play out. I think this is great. I think it's moving forward. One of the things I would say is the church has been successful in silencing victims for years. And I know, Carol, that you said that, they're not going to extend it, they're not going to wipe out any limitations. I can only say that they have been very successful in silencing witnesses for years, utilizing the confessional, which is something they tried to utilize with me. They tried to get me to go under the seal of confession. There's a thing called the papal secret, which people who believe are threatened with burning in hell if they ever tell. It's a real thing. And for those people who are left in this world, you know, beyond that 35 years from the time this may be enacted, all the more reason why maybe you should consider extending it or even trying to come up, because those people aren't going to live forever and they'll never get justice. And if this is passed now, which is great, it's only going to cover people to like 58 or 60 years old, whatever it is. And how about 53?
It'll cover people to 53 unless you have repressed memory or you made the causal connection after the age of 53, then you have 7 years.
So you still have the 7 years from the time,
That you recall or you make the causal connection
and so that's going to be applied to the institutions as well.
as well.
Okay. Well, thank you.